later learned his name was Mr. Kandie. I think he was the regional boss. And Mr. Mahmoud, so OSPD, absolutely aggressive. So they tried to abduct Mr. Tuju, force him into the waiting Subaru, and he was in the process, for a moment they left him in pain, consulted. We told them, if you had wanted us to deliver you to this area, we would have done the same. You don't understand the whole. And the process, they seriously hurt him. Adding to the injuries that are of the current hospital, who actually escorted him all the way to the UK. That time, President Kenyatta was in office, and they ordered his minister to be evacuated, and that's how his life was saved. That he has been under care of Dr. So, I must have the officer in charge of the current hospital, because we pleaded, saying, how do you ask a doctor to examine a patient inside the police cell? So it amounts to even arresting the doctor. But they were kind, there are no lights at that cell. Eventually they said they could make available some lighting. They allowed the doctors to stay overnight, making sure Mr. Tuju's life was preserved. Therefore, Your Honor, I stand here to say what we saw yesterday should not happen in a democratic state. When we enacted Constitution 2010, we even changed the title of the police force from National Police Force to National Police Service. What we saw yesterday was real force, brute force, abducting a Kenyan citizen because he has served. And then because of that, we invite you not to proceed in any manner this unfortunate prosecution. I'll invite Council. You go first. Rushed to hospital. What I witnessed was unfortunate bureaucracy. Our sons more than 3 times to wait for another 20 minutes. They are consulting the seniors. And at some stage, I remembered the telephone contact of the deputy KISII, Mr. Onyango, whom I called, and he said he was sending an officer in the Nairobi area. I think eventually an officer came, better land. She's but they could not take a decision on a person who is dying in their presence. And I suggested to them, then why don't you take even the policemen who are in yeah, these days it's a tradition for even public officers to hide with their persons. I said even those carry the handcuffs, put on Mr. Tuju's legs, if need be, and take him to hospital. That request, which I made consistently, was declined. But this morning, lo and behold, I've decided to take him to hospital. The owner of that phone? It sounds.
Before my before I was against the reform of senior council, you know what has but most importantly, so that you know we could be in a position to tell the chain of custody and to understand whether or not our client was under arrest. You know, that never happened. At the time we were leaving Karen at around 8 o'clock or thereabouts or 7 in the evening, that entry had not been done. I requested as a regional deputy to have it recorded. Mr. Ombati, the gentleman present. But that was never happened. Number 2, Your Honor. Will not have any legal basis for that deferment, because we are deferring a charge that is relating to an individual who is before submitted to the jurisdiction of the court, so that the court then can be able to exercise its jurisdiction as against that individual. So in the absence of the accused person, how will this court exercise its jurisdiction? Granted the explanation given by senior counsel and the information that the person to whom the charge relates is currently hospitalized, courtesy of injuries that accrued from police brutality, Your Honor, I am of the view that the court has not jurisdiction. Because your jurisdiction is drawn from the criminal procedure code. The mere presence of a charge sheet before Your Honor does not confer you with jurisdiction in the absence of an intended accused person. And I'm using the word deliberately intended accused person because that person is not before you. However, be that as it may, and because we have seen the intention of the state to prosecute our client, will equally invoke the provisions of Article 49 in terms of granting our client bail pending appeal, because there is a charge sheet before you, so there is intention. There is intention. And because I can read my learned friend's mind, you want to allow me to direct you to the same specific provision. It relates to an arrested person. An arrested person has the right to be brought before a court as soon as reasonably possible. H says to be released on bail on bond or bail on reasonable conditions pending a charge. That is where I premise my position on. This charge is merely indicative of the intentions to prosecute. And as such, Your Honor, you can invoke the provisions of Article 49, verse 1 page, so that we may secure his freedom as he undergoes his treatment. I invite my...
You know, I think my request to the court, I think Tuju could be simple in this way. It is not in doubt that it's not before you.
I can hardly hear you.
It is not in doubt that it is not before you, and the explanation has been given.
The request we make is this. Consider, Your Honor, allowing that to, I'm using the word defer, the plea on terms, Your Honor, on terms of freedom, and give us a return date, perhaps in 2 weeks or so, subject to remarks or documentation on the status of Honorable Tuju's health. Because what we have before you is information that hasn't been presented to you accept the fact that he's currently under examination at current hospital. So the request could please consider deferring the plea on, because Honorable Tuju is a public figure, he's not a risk, flight or other. He'll show up in court us and get the right. That's the request we make on behalf of Tuju. I think the rest here, we should be able to deal with them in his presence. That's all.
Anyone from defense? Defense, do we have anybody else?
For there to be a charge, and this particular charge being proposed is one which should be in persona, but not in realm. And therefore, the explanation after the charge, the misleading information must have been given not in realm the way it's been framed. So the charge before you on the face of it, Your Honor, I submit, has no basis of law and should be rejected.
Your Honor, just one. Rang me last night. That former Governor James Orengo,
And who else did you say? You said two people.
Sorry, Your Honor, no, just that.
Okay. Defense, are we done?
We are retaining some power for
the jurisdiction of this court has been questioned. Let me address that. You are told that this court lacks jurisdiction by an absence of an accused person. That's legal, misleading, and inaccurate. Now, in the CAA authority, which I believe is in all of us, the jurisdiction of a court is granted by the Constitution or the law. It is not granted by the presence or absence of an accused person. Now, this court is characterized as a subordinate court by the Constitution of Kenya, and the jurisdiction of subordinate courts is granted by Article 169 of the Constitution. And then that particular article of the Constitution is given effect to by the statute called the Magistrates Courts Act 2015. In addition to Article 169 and giving effect thereto, the criminal jurisdiction of this court is granted by Section 6 of the Magistrates Courts Act. To be more particular, as regards offences under the Penal Code, Section 6, subsection A of the Magistrates Courts Act 2015. so that this court has jurisdiction, whether or not an accused person is present. You know, one of the innovations of the new constitution is that even in the absence of an accused person, although the circumstances are important, where it is impossible, or rather it is impossible to proceed with proceedings in the presence of an accused person, then a court...
Presence or absence? No, you will not listen. It's okay.
Not I will not, I cannot. I cannot receive. That one of the innovative inclusions of the new constitution is that a case can proceed even to conviction in the absence of an accused person.
Mr. Ruto, as an advocate, what are you doing? Are you an accredited? As an officer, is that proper? This is not just for your database already. What did I say earlier? Mr. Ruto, you're an advocate. What did I say earlier? You didn't hear.
We respond that the absence of the suspect before you does not take away the jurisdiction of this court to consider the matter. Having said that, Your Honor, we sympathize with the factual matrix given by the Honorable former VP as regards the circumstances surrounding the arrest, which otherwise they characterize as an abduction of the suspect. However, Your Honor, as confirmed by the defense counsel, Honorable Tuju is at Karen Hospital as we speak, having been taken there by police officers from the Karen police station. The right thing to do this morning than to drag a sick man to hospital, the police officers, sorry, to court, the police officers took him to the Karen hospital. It is confirmed by the defense. We wish Honorable Tuju a very quick recovery.
Yes.
A suggestion has been made, without basis, with a lot of respect, without basis, that the charge sheet before you is defective. An interesting argument is made that the charges are in personam as opposed to being in rem. We agree that the charges are in personam. Questioning the defect in the charges cannot happen in the absence of the accused person. While the court cannot lack jurisdiction in the absence of an accused, the viability of the charges cannot be questioned in the absence of an accused person. Interesting twist like that. The question as to the defect or viability of the charges can only happen in the presence of the suspect. As regards the charge sheet, you've also been told, which ties to the question of jurisdiction, that in the absence of an accused or a suspect, we do not have charges because the validity of charges depends on the presence of an accused. False. The validity of charges is based on the Criminal Procedure Code, Chapter 75 of the Laws of Kenya. And it says that a charge shall be sufficient if it has a statement of the offense and particulars sufficient enough to respond there. And as we're talking about Section 216, I may need to confirm that a charge shall be viable if it has a statement of the offense and it has particulars sufficient to answer there. But as we have said, without the accused person, whether or not the statement and the particulars are sufficient cannot be a question to be addressed in this absence. charges are as against the accused person and not his advocates. The final point we address is whether or not this court can grant what I think my learned friend has called bail pending appeal in error. Oh, it was correct. Oh, it was corrected. I'm sorry, it was corrected. Bail pending charge. Yeah, my friends, I agree.
It's not very obvious for me.
I will withdraw that. That the accused person in his absence be granted bail. We are opposed to the grant of bail in the absence of the accused person. We already, however, alerted our colleagues that we were not going to oppose bail upon charges. Why, Your Honor? Because the court has been informed that the suspect has been hospitalized and a factual matrix has been given about certain injuries. My colleagues have not used the word violation, but that's what I suspect they were indicating to the court. This court needs to see the suspect, assess his condition as soon as he's able to get back on his feet and is able to understand the proceedings, make appropriate orders, including an order pursuant to Article 49(1)(h), which is an order for bail. We therefore, in the alternative, propose that it is in the interest of all, or rather both sides, both the defense and the prosecution, that Honorable Tuju gets treatment as a matter of urgency, and that in our alternative proposal, as soon as he is back on his feet, appears before this court, the parties to address the viability of the charges. If we agreed on their viability, he proceeds to take plea, then the court can grant reasonable bond terms as is in the words of the Constitution. We therefore agree with the proposal by my friend, my learned senior, Mr. Oonge, that for today, these proceedings are to be deferred until the subject thereof is able to understand the proceedings. We then shall come back as to the question of plea and bail bond. With reservation to my colleagues, if they have anything else to add, and subject to the court's questions to me, I'm glad to appear before you today.
You're welcome. I just want to find out, when defense was submitting, somebody talked about 2 weeks. Was it you, Mr. Njiro? 2 years, yes. So he says until that happens, prosecution, are you in agreement? It's okay, Mr. Onge, I just want clarity from the prosecution as to whether they are in agreement with the 2 weeks or not.
I'll take 1 week, like my seniors proposed, we mentioned the matter in 1 week. Mr. Tuju does not have to come in that 1 week if he shall not be in good health.
So 1 week for update.
Yes, we could also be 1 week, 1 week for the mention.
For mention for what purpose?
To confirm the status of his health. If he shall be fine, we have our trash sheet.
For update on his health status.
Yes. We also humbly request that a medical report to that effect is available to court.
At that time.
Yes.
My clarification with the supervision of my senior counsel,
Mr. Onge, please, just, I said my proceedings must be they must make sense, even to whoever is reading after this. Let us give the prosecution time. I'll give you a very brief moment for rejoinder. Is that okay? Because it's the defense that went first. So prosecution, you have all the time. My prosecutor, Miriam, you have all the time to add on to what Mr. Owiti has said. Not all the time as it were, but a chance other members of the public in court who are waiting to be served.
Who of you will go? Yes, go ahead.
No, you're not. Just one addition, because I don't want to take what my colleague has said.
Yes.
But the issue of reaching at point 49 of the Constitution, I beg to differ with my colleagues. The defense, because we proposed or suggested to the court that that has been breached. Your Honor, we are here to say that Article 49 has not been breached.
Yes.
The only reason why the accused person is not presently before court.
Concession was made on one.
The third concession was within the 70s. But the clarification I think I'll see from Ghana friend, MANYORA is Mr. Tuju still in police custody? Is he under arrest? Despite the fact that he's to give him, would they then undertake that in the intervening period of 7 days, the public backs off and lets him enjoys treatment of
So
him?
do I say backs off? Because I want us to be clear on what we are saying. What is the right?
Now that the investigators are in court, we have their undertaking that is not under.
Be facilitated to have his treatment without the necessity.
Be facilitated by who? Because you are saying that.
No, we are saying is, what the request we're making is, can the police then, for example, not I think that's the question to ask. Yes. The deed is,
So I remove the part of facilitation.
just remove the facility.
First,
What am I usually gonna- yes.
I think
So up to that, can they undertake that he's not under arrest?
under arrest, pending the 7 days.
Pending the 7 days.
Pending appearance in court for 7 days.
Yes, Your Honor.
Just a moment. In the 7 days. Yes, is that all, Mr. Onge?
I think that's what we have that like.
And is there anybody from the defense who needs to put up, maybe just say something else, so that if the prosecution are responding, they respond to us? Yes, Senior?
Your Honor, I heard it from the arresting officer yesterday that Mr. Tuju was not under arrest. That was the basis on which I actually volunteered to take him to current police station. We concede that you have jurisdiction.
Or you do?
Yes, we concede. That's why we are here. We respect our courts of justice. But you know, because you have that jurisdiction, we want to urge that you order that if indeed Mr. Tuju is under arrest, contrary to what I was told by the arresting officer, that you order that he be released forthwith. brute brutality by the police against, until now, an innocent Kenyan. So, Article 49, Your Honor, tell what before you. Article 49 of the Constitution. The rights of an arrested person. That even in that form, we invite you, Your Honor, to order that if they insist is arrested, that he be released on bond or bail on reasonable conditions pending the charge. Our submission before you, Your Honor, is no charge before you. You have jurisdiction, yes, but there is no charge before you. In order to facilitate Mr. Tuju's quick improvement recovery, Your Honor, I invite you to order that he be given medical treatment without the presence of the police.
And then the room has this way.
These are direct. My friend actually confirms. Thank you, Your Honor.
Right, prosecution, just that aspect.
Just 1 minute to Mr. Okach.
I give 3 minutes, they are up.
Yeah, you can always exercise further jurisdiction.
Just because you've accepted, Mr. Okar, in less than a minute,
I'll try, I'll really,
if you don't, I'll stop.
Your Honor, there are only three issues. One, the jurisdiction is not only encompass the jurisdiction where we are also asking you to exercise, especially in the case of what senior counsel has said, is under Article 20. The issue of protection of any person against torture, inhuman or degrading conduct. The law is clear that you have that jurisdiction. Secondly, Your Honor, you have been told that you can even proceed in the absence of an accused person, and that is true. But what Mr. Owiti is not telling you clearly is that that can only be invoked if the absence is something that someone has created by himself, an accused person. In this circumstance, Your Honor, it is admitted that the accused person is not here on a volition of his own. He went voluntarily to a police station, taken by and immediately he was assaulted. And after that assault, all what JD can tell you is that we sympathize. They just, oh, Mr. Witty, my apologies. I know him. They just say we sympathize. Your Honor, someone kills your child, then says I sympathize, I'll give you the casket and I'll give you fair home. That's what they are telling you. Your Honor, it is not proper, and those circumstances under which the person is not here is something that the court ought to consider, and especially when it comes to the request to grant personal bond. Because that person, by conduct, and the state has not controverted that issue, he took himself. That is the only major consideration that this court ought to make. So that if my colleague is talking about the issue of bail in the absence of bail by this person, you have the power and the right to consider that. And they have not told you even one issue that will say that they will even be opposing bond. In fact,
by their own admission, they have told you, we were not going to oppose bond. They are telling you this person is not a flight risk. Even if you grant him personal bond, he will appear here within those 7 days. And that is the request we are making. Let this person be given personal bond. The court says, the law says, once they have arrived, we have come here, that person is in your hands. That person is in your hands. Time is up, my friend, Your Honor. But that person is in your hands. That person is in your hands, Your Honor, not our hands, not the state's hands. Your pen is what will determine what happens there. Thank you so much.
Prosecution, I guess that is back to you to confirm or to answer to what the defense has raised in less than 3 minutes.
Yes, Your Honor.
You're not to the extent.
Hey,
You're not in only one thing.
My Excellency.
You know, pardon. You understand, we are the ones who make the application and move.
Yes, yes.
So I highly bet that he has no ability to address even that clarification. We are sitting on, you can make it there. Because he has no audience. Mr. Park, Mr. Owen, he has no audience.
He has no audience.
He has listened to our application.
You addressed the court first as the defense, right?
Yes.
You raised issues or matters or concerns that the prosecution had to respond to, right? And then now we are back here saying, let them confirm whether he's under arrest or not, so that then we know the way forward. Did I get you right in summary? Yes, he has a right of withdrawal.
Your Honor, thank you for the guidance. Ms. Andrea has a bit of taking over courts. I'm glad this court has not allowed him. But Your Honor, there's a new issue that has been raised about.
You know that's a very serious accusation.
Can I please, just a moment, counsels, can I please this aside and serve the Mkomo Mwananchi who is waiting for me? And then maybe we record a consent on the way forward, is it possible? Because if we do this back and forth like this, it's going to take long. There are people here who need to know what is hash bill, what is the fine, if any, so that they start looking for it to pay before they're taken to the
I just need to raise a new issue that we can find about torture. And if you allow me, in addition to answering the question as to whether Mr. Tuju is in custody, allow me to start with the response to that. You've been told a lot of factual matters I mentioned earlier, none of them on an affidavit. I do not have any reason to doubt the Vice President, the former Vice President of Kenya. And I repeat that we sympathize as the prosecution from the factual narration. However, there is no evidence, which can only by way of an affidavit, to the extent that there has been torture or inhuman and degrading treatment, which then would involve Article 5. Before that affidavit fits on your desk, this court cannot be persuaded by allegations of torture and inhuman and degrading treatment. Thank you on that point. Is Honorable Tuju in custody of the police? Yes. The OB number is OB 31 stroke 23 stroke 3 stroke 2026.
Let's take that again.
OB number? Sorry. OB number 31 stroke 23 stroke 3 stroke 2026. Even in hospital, he is in the custody of the police. It is the prosecution's position that even pending appearance, he will remain in the custody of the police until and unless we are back to this court earlier, if that is possible, or the police in their own discretion, which the Director of Public Prosecutions cannot get into, consider a grant of police bail. I thank you.
What is the essence of this?
Yes, please.
Prosecution, Mr. Mutuma, Ms. Marianne, Ms. Nora.
No, nothing here.
All right. Nobody has told me how long.
But we undertake that we are ready to come back before you as soon as even before the 7 days, just to talk about the other issues.
Right, the reason I ask is because I want to make a decision based on submissions by local business and in light of the fact that the prosecution has confirmed that politically suspect for purposes of this case,
Under the nature of injuries spinal. Yes, because he had a previous spinal injury, and which was now reported by the police station. He may be checked by him.
And you're
it's okay, they've already seen. Yes. And doing what? Okay, so I have had all of you, both the defense and the prosecution report, and I will give myself time to retire to chambers and look at ruling on all the concerns that have been raised and the response that has been made. So I'll give my ruling on Thursday, 26th of March, 26 at 12 o'clock. At 12 p.m. so that I'm able to cover all that you have talked about. Remember, we talked about, okay, this concession on jurisdiction, but we are talking about bail bond, then the fact that he has not yet taken the plea. We're talking about the issue of police custody now up to the 7 days that we have agreed about. Let me give comprehensive directions on Thursday.
To hospital to receive medical attention.
Yes.
They declined.
Yes.
When he was supposed to be
Now, once we my worry, and I hope that as my peers are not confirmed, we may live here, and again he's removed and taken for to be distressed
again as a cell.
Prosecution.
No, Your Honor, Mr.
Because
Okach.
and I don't want us to preempt what the doctors will tell us as we discuss this.
Your Honor, Mr. Okach has severally given you misrepresentations that number one, that Honorable Tuju was taken to hospital 40 minutes ago. 40 minutes count as in this court. He was taken to hospital 2 hours ago, number one. Number two, at least I am not an animal. I would not want anything to happen to Honorable Tuju. What we are pleading with the court, and Mr. Okach can call me if he doubts any other person, including the police. Whenever he thinks that the scenario is worsening or let us know. Let's put it in the public domain. But Honorable Tuju is in a hospital.
Okay, stop, Mr.
Yes.
Please stop. Yes, Mr. let me just, because I see there's a lot going on.
With your Honor, with your kind permission, can I make one concession?
Senator, you can't,
May I, with
you
your
have
kind
to
permission?
let me speak. This is my point. For now, he's here. I'm trying to say, there seems to be a lot going on. And then it's that big.
Yes, we may, Your Honor.
First of all,
yes, that
before we do the math, can we agree
Yes, we
that we
concede.
bring it one day for
Yeah, we concede, but
at
only,
12 o'clock?
yes, we concede, but only the one right there, Your Honor.
Yes.
We are looking at the situation. As we speak, we do not know the circumstances and the advice that the doctors will give. It may include that you also need to get some specialized treatment. How will that be, and it may even be now or even tomorrow. If he's still going to be under the custody of the police, how will that be facilitated, Your Honor, if we leave this court without a pronouncement as to the status of his bail and bond?
That is why I have said, okay? Let's not even preempt what the doctors are going to say. Let's not micromanage what the doctors are going to say before they even say that. That is why I have said, come back before me tomorrow at 12 o'clock. Yourselves, the prosecution and yourselves have just said, the doctors are on it. I wish that I had something medical before me to give me an idea of what we're looking at. So between today and tomorrow, the senator has just said in his final, will be taken back to the police station. Assume that is what it is. And let's not assume, that is why I'm saying, let's give the doctors time to do that which they must do. Why is it?
Your Honor, I was suggesting both
Yes,
of
you
us.
came here with a very fixed mind. That means fixed on this side and fixed on this side,
Your Honor,
except for the court.
if both prosecution and defense can forward to you by this evening a provisional medical report, Your Honor, I think that will help the decision.
Now, instead of you forwarding to me any medical reports this evening, okay? Can't you just consent right now, both prosecution and defense, because you have had, and it's confirmed, he's under arrest, he's with the police. Can't you, prosecution and defense, consent that we let it be until tomorrow when this court gives directions on the way forward? Is it so hard for us to do that? Because then, these are things that we can agree upon. Remember, the doctors might say it's worse than it seems. They might say there's nothing. They will give us the work, whatever it is. Can't we agree? That pending the directions of this court, we let the doctors do their part. Then, if you so wish, you can even appear before me tomorrow, before this 12 o'clock, or forward to me the medical reports before I make my pronouncement. Tomorrow morning, not tonight. This, yes.
In the meantime, I just bring to your attention that this is a matter of great importance to the welfare of this country's citizens. That's why some of us have come. And every reason. In fact, my learned friend here from very sincerely told the police commander to let him know. We're dealing with a very serious matter.
All right.
So we will take your position that we need to know.
It's all right. Let me say this. Do not think that the court does not understand the magnitude of this matter. Senior, thank you for reminding us, all of us. But what I'm saying, we are not able to agree. I have brought it forward binding. And the reason I asked for something medical, to just tell the court this could be what it is, and allow me to give my direction in addition to what I have just said. 26 at 12 o'clock. In the meantime, let the patient, the suspect, Honorable Tuju, whichever you please, be availed comprehensive proper medical attention to avoid further injury and or deterioration. I cannot say for sure let him remain admitted, let him be discharged, because I have no idea what we are talking about in terms of the degree of injury or illness or aggravated illness. I hope that makes everybody feel better. And prosecution matters help.
You know, we acted on that. And that's why it's
Honorable Kalonzo, I'm sure. And when the court says comprehensive medical attention, I don't tomorrow at 12. Okay, after me, please leave my coat so that I can continue with the other matters. Thank you. Let's leave. I have matters to attend to. Let's talk outside.
Excuse tunapesa. Wamalu asipo na now we are able to get so guys, tunakimbia Karen. Wamesema wanaenda hospitali. Mko na gari yenu huku? Niwadandie niende na nyinyi. Halo. Niombe tu lift sasa. Hata siombi tena. Mfungulie gari. So guys, I'll be live in a few from Karen.